Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with the government's response to Thomas Farinella's motion to dismiss from August 9th. And one thing I'm going to say about them chicks over there at the Eastern District of New York. So if it was any other case, I would be like, oh, I love their spirit. But because it's this particular case, you know, they some little smart mouth heifers, okay? And they just have little respect for Thomas Farinella. But before we get into this response, I want you guys to go over to my community page, because I put up, if you remember in my last video, I said that I was going to try and create a cheat sheet on who all of these Jane Does are. So I did a little bit of research. I came up with 13 of the 20, and then a couple of people commented, and so we added one to number 14, which we're going to make that Maxine Daniels, who was the daughter of Regina Daniels and her husband, who worked with R. Kelly, and he dated their college daughter. She was like 21 at the time, and it really looks like it fits the bill. So we're going to go ahead and make 14 Maxine Daniels. But I would love for you guys to chime in the comments and let me know who you think the other people are that I was unable to figure out their identities. And then if there are any that you think I got wrong, go ahead and let me know that also. And then maybe eventually we can figure out who all 20 of them are. So let's go ahead and get into this response. It says, Dear Judge Donnelly, the government respectfully submits this letter response in opposition to the defendant's motion to dismiss filed on August 9, 2021, which was docket number 159 in this case. The defendant moves purportedly pursuant to federal rules of crime procedures 12B2 to dismiss 1 racketeering acts 1 through 3, 7, 10, 12, and 14 of count 1, and then 2 counts 6 through 9, and 3 the entire indictment for lack of venue. For the reasons set forth below, the motion is both untimely and meritless. It should be denied in its entirety. And if you want to learn more about that indictment and what it entailed, let me see what the name of that particular indictment was. Let me get in here real quick and go to my content, and that was from the 9th, and I think I believe it was the one where it says, is the government piling on witnesses? So it's either, I think it's that one. If you want to know exactly what his response was, that's the video that I used. Okay, and so let's get back over here. Okay, so number 1, the motion is untimely. In a transparent effort to avoid a finding that his motion is untimely, the defendant asserts that his motion is made pursuant to Rule 12B2 of the Federal Rules of Criminal Procedure. And that, I actually brought that up. I hope I didn't close it. I didn't close it out, so let's see what that says. Let me close this. Oops, cancel. Okay. So they said 12B2. So 12B2 states, So 12 pleadings and pretrial motions. B is pretrial motions. 2 is motions that may be made at any time. A motion that the court lacks jurisdiction may be made at any time while the case is pending. And so basically, he filed this motion after the date that Judge Donnelly had given for all motions to be filed. And so he was using this rule saying that he could turn it in late because he's talking about crimes that are in other jurisdictions. So it goes on to say, here the defendant does not assert that the court lacks jurisdiction. Instead, he asserts that 1, certain racketeering acts and substantive counts should be dismissed because they fail to state a claim under New York law. 2, once the court dismisses those racketeering acts and counts, this results in a lack of venue in the Eastern District of New York. And 3, certain racketeering acts related to the creation of CP should be dismissed because there is no evidence that visual depictions exist. And 4, certain racketeering acts should be dismissed because they are purportedly beyond the applicable statute of limitations. And then it goes that you can find those at 5 through 13 on the motion that Thomas Farinella filed. Notably, the federal rules make clear that motions alleging a defect in instituting the prosecution, including improper venue, and a defect in the indictment or information, including failure to state an offense, must be raised by pretrial motion if the basis for the motion is then reasonably available and the motion can be determined without a trial on the merits. Federal Rules of Crime Procedures 12B3, AI, and BV. The federal rules further provide that the court may set a deadline for the parties to make pretrial motions. If the court does not set one, the deadline is the start of the trial. Federal Rules of Crime Procedures 12C1. If a party does not meet the deadline for making a Rule 12B3 motion, the motion is untimely, but a court may consider the defense objection or request if the party shows good cause. And that is from Federal Rules Criminal Procedures 12C3. And since this motion was filed, Judge Donnelly did enter that if Thomas Farinella wants to respond to this motion, he has until to this opposition from the government, he has until August 16th to do so. So properly construed, there can be no doubt that the defendant's motion is in fact a Rule 12B3 motion. Apart from his initial invocation of Rule 12B2, without more, the motion is replete with references to the fact that the defendant is challenging the sufficiency of the indictment. And then they tell you, see defense motion at 3. Indeed, his argument with respect to racketeering Acts 12 and 14 of Count 1 and Count 6 through 9 is that these racketeering acts and counts fail to state an offense because the underlying state law violations on which they rely either 1, do not include herpes, or 2, the indictment does not allege conduct amounting to reckless endangerment under state law. Nor is his meritless statute of limitations argument jurisdictional. See Masaccio versus United States, 577 U.S. 237, which was a case from 2016, claimed that indictment charged offenses beyond the applicable statute of limitations was not jurisdictional. And that was the ruling in that particular case. And so that's what they're using to support what they're saying here. Finally, his claim that venue in the Eastern District of New York is improper falls squarely under Federal Crime Procedures 12B3 AI. So here the court set a deadline for the parties to make pretrial motions following several adjournments of the trial date. On February 9, 2021, the court set a July 19, 2021 deadline for such motions. With the government's consent, the defendant moved for a 1-week extension to the motion's deadline to July 23, 2021, which the court granted. As a result, the defendant's motion filed on the morning of jury selection is untimely. The defendant has provided no good cause for his untimeliness, nor could he. The defendant's suggestion prior to the start of jury selection that he needed recently produced discovery to make his motion is baseless. See transcript of criminal cause for jury selection on August 9, 2021 at the number 6, this, or it could be page 6, I'm not sure. His motion to dismiss the racketeering acts and counts related to herpes exposure and the correlative venue challenge are based on misguided arguments as to the reach and applicability of the underlying state laws at issue, not any substantive evidence produced in the discovery. Indeed, that is why the defendant previously filed a motion to dismiss the very same racketeering acts and counts related to herpes exposure over a year and 4 months ago on March 2nd, 2020, docket number 42. The same is true with respect to the defendant's argument regarding the statute of limitations. As a result, the motion should be denied. And so when they're talking about the motion from March 2nd, 2020, I believe that was a motion that was filed by Greenberg, where you guys have heard me talk about where he was just throwing stuff at the ceiling and hoping that something stuck. But he was talking about some law that pertained to same-sex couples. And then he was talking about the law was created, as I was sharing with you in the previous video, that this law about herpes was designed to protect military personnel from getting diseases, sexual transmitted diseases, and that it does not apply to this particular case. And so that is the motion that they are referring to. And then let's backtrack up here for a second, because they have a note at the bottom of the previous page. It says, as set forth below, this portion of the motion is not a proper basis for a pretrial motion to dismiss, as it clearly argues evidentiary insufficiency. The defendant may not challenge a facially valid indictment prior to trial for insufficient evidence. Instead, the defendant must await a Rule 29 proceedings of the jury's verdict before he may argue evidentiary sufficiency. United States versus Kelly, and they are not talking about this Kelly. They're talking about somebody else from a case in the Southern District of New York from 2000. Okay, so then it goes to the motion also fails on the merits. A, the charges related to herpes exposure should not be dismissed. Counts 6 through 9 in Racketeering Acts 12 and 14 of Count 1 each relate to violations of the Mann Act. More specifically, these racketeering acts and counts collectively allege that on or about May 18, 2017 and February 2nd, 2018, the defendant, 1, transported Jane Doe number 6 in interstate commerce with intent that Jane Doe number 6 engage in activity for which a person can be charged with criminal offense, specifically violations of New York Penal Law, Section 120.20, Section 120.20, reckless endangerment, and New York Public Health Law, Section 2307, exposure of infectious venereal disease in violation of United States Code Section 2421A, and 2, persuaded, induced, enticed, or coerced Jane Doe number 6 to travel in interstate commerce to engage in sex for which a person can be charged with criminal offense, specifically violations of Section 120.20 Point 20, reckless endangerment. And Section 2307, exposure of infectious venereal disease in violation of United States Code, Code 18, Section 2422A. The indictment further alleges that the defendant violated these New York state laws specifically by engaging in unprotected intercourse with Jane Doe number 6 without first informing Jane Doe number 6 that he had contracted herpes and obtaining her consent to sexual intercourse in these circumstances. And for those of you who are not familiar with Jane Doe number 6 is Faith Rogers. So number 1, New York Public Health Law, Section 2307 applies to herpes. And if you recall in the previous video, Thomas Farinella was making the case that herpes is not a part of Section 2307 because at the time that 2307 was written into law, herpes did not exist, that the law was later amended and herpes did not exist at that point. And then after herpes became a medical diagnosis, that New York did not go back and amend the law to include herpes. And then he also made the argument that herpes is a virus. It is not a bacterial infection such as syphilis and gonorrhea. Therefore, it does not apply to this law. So the government is saying that New York Public Health Law Section 2307 provides that any person who knowing himself or herself to be infected with an infectious venereal disease has sexual intercourse with another shall be guilty of a misdemeanor. The defendant argues that it is undisputed that Section 2307 does not include herpes. And then in the defense motion at 4, he is wrong. Herpes is clearly an infectious venereal disease, and as a result, Section 2307 encompasses herpes, as New York state courts have repeatedly found. And then they cite a couple of cases, Maraham versus Maraham, which Section 2307 provides basis for valid civil claim where a husband failed to disclose to his wife that he had herpes before sexual intercourse. And then Fan versus Sabin, which was from September of 2015. And then that Maraham case, that was from 1986. In civil, and then in this one, this 2015 case, in civil case where plaintiff alleged that defendant, who was plaintiff's ex-boyfriend, had unprotected sexual intercourse with plaintiff knowing he had herpes and without first informing her of same. Section 2307 imposes a duty to disclose. This comports with the plain meaning of the statute. See Nozuzu versus Holder, which was a case heard by the Second Circuit in 2013. When interpreting a statutory provision, we begin with the language of the statute. If the statutory terms are unambiguous, we construe the statute according to the plain meaning of its words. Let me take a moment, y'all. I'm getting tired-tongued him. The dictionary definition of venereal disease is a contagious disease such as gonorrhea or syphilis that is typically acquired in sexual intercourse. And then they had the audacity to cite the Merriam Dictionary in case Mr. Farinella needed help. And then it goes on to say, or more succinctly, a sexually transmitted disease, and then says see dictionary.com. While gonorrhea and syphilis are listed as examples in the Merriam-Webster dictionary definition, they are not exclusive examples of contagious diseases typically acquired in sexual intercourse. According to the Center for Disease Control and Prevention, Genital herpes is a sexually transmitted disease, STD, caused by the herpes simplex virus type 1 HSV-1 or type 2 HSV-2. And then it gives the website to the CDC site where they talk about it. And then they go on to say it thus squarely falls within the definition of a venereal disease and therefore within the ambit of Section 2307. That the Public Health and Health Planning Council of the New York State Department of Health issued a response to a public comment on an unrelated regulation regarding the expansion of minor consent for HIV treatment access and prevention does not alter this conclusion. See defense motion at 5 through 7. The issue of whether Section 2307 covers herpes was not before the Council, and in any event, the Council's response to a public comment is not binding on this court. The term venereal disease is not ambiguous, and its plain meaning clearly encompasses genital herpes. New York State courts agree, as should this court. Finally, Plaza versus Estate of Weiser, which had a deposition in 1995, is in opposite. Defense motion at 7. There, the court found that Section 2307 excludes HIV infection, not because HIV is not an acute bacterial venereal disease, a CID, but because New York's public health law has entirely separate statutory schemes for HIV-related testing and for the examination of persons suspected of being infected with the other venereal diseases. And then they cite the case. The court found it significant that while there are mandatory testing requirements related to those suspected of being infected with venereal disease, the New York State Legislature has specifically excluded persons suspected of being infected with the HIV virus from being compelled to undergo such testing, citing New York Public Health Law Section 2781 and matter of Michael W.W. Third deposition 1994. It appears, therefore, that the Plaza Court relied on the fact that following the enactment of Section 2307, the New York State Legislature had later enacted an entirely separate statutory scheme specifically related to HIV to exclude HIV from Section 2307's ambit. No such entirely separate public health statutory scheme exists for genital herpes. As a result, the defendant's reliance on Plaza is of no avail. And then they have a note at the bottom of this page and says, while irrelevant to the legal analysis, genital herpes is not a relatively new phenomenon, as the defendant appears to suggest. See defense motion at 7 through 8, arguing that the concept of genital herpes was created in 1967, 21 years after the last modification to Section 2307. Notably, the virus responsible for genital herpes likely jumped from prototypes to a now extinct hominin, either Homo habilis, Homo erectus, about 1.6 million years ago. So they are citing a article from the Washington Post that was about herpes has passed from chimps long before humans existed, a study found. So they're basically saying that even though it was only registered in 1967, that there is documented that it was amongst, I guess, animals a really, really long time ago. So number 2, the conduct alleged in the indictment violates Section 120.20 Section 120.20 provides that a person is guilty of reckless endangerment in the second degree when he recklessly engages in conduct which creates a substantial risk of serious physical injury to another person. Under New York law, a person acts recklessly with respect to a result of circumstance when he or she is aware of and consciously disregards a substantial and justifiable risk that the particular result will occur or that these circumstances exist. People versus Galatro, and that was a New York case from 1994, citing New York Penal Law 15.053. As the New York Court of Appeals has made clear, the reckless endangerment statutes seek to prevent the risk created by the actor's conduct, not a particular outcome, and the risk of jury alone will sustain prosecution. Galatro, internal quotation marks omitted, serious physical injury means physical injury which creates a substantial risk of death or which causes death or serious and protracted disfigurement, protracted impairment of health, or protracted loss of impairment of the function of any bodily organ. New York Penal Law 10, Section 10.0. Okay, well, none of those apply to genital herpes. Like, it doesn't cause physical injury, it doesn't cause a risk of death, and it doesn't cause death or serious and protracted disfigurement. So none of that applies. So I don't know where she's going with this, but let's carry on. Each of the alleged charges alleges that the defendant violated both New York Penal Law Section 120.20 and New York Public Health Law Section 2307, in that he engaged in unprotected intercourse with Jane Doe number 6 without first informing Jane Doe number 6 that he had contracted herpes and obtaining her consent to sexual intercourse. In these circumstances, such conduct clearly meets the elements of reckless endangerment in the second degree. Indeed, the New York Court of Appeals affirmed this very conclusion in similar circumstances in People v. Williams. The defendant engaged in unprotected sex with the victim knowing he was HIV positive. I don't understand why they keep comparing HIV to herpes. Because HIV can lead to AIDS, and AIDS can create complications within an individual that will lead to death. Most likely will lead to death because there's certain cancers it attacks, vital organs, with different types of cancers and diseases. So I don't think that you can make that connection or that correlation between herpes and HIV. To me, this argument doesn't make any sense. So it says he was HIV positive and without informing the victim of his HIV positive status. And this was a New York case from 2015. The district attorney sought and a New York grand jury returned an indictment charging the defendant in Williams with, inter alia, reckless endangerment in the first degree in violation of New York Penal Law Section 120.25, which criminalizes recklessly engaging in conduct which creates a grave risk of death to another person under circumstances evincing a depraved indifference to human life. And then they give them where that's located, 1131 through 32. The trial court held that the conduct at issue did not constitute first-degree reckless endangerment and reduced the count of first-degree reckless endangerment to second-degree reckless endangerment in violation of New York Penal Law Section 120.20. The appellate court and the New York Court of Appeals affirmed the trial court's decision. In so holding, the New York Court of Appeals found that the conduct did not meet the legal standard for depraved indifference because there was no evidence that the defendant exposed the victim to the risk of HIV infection out of any malevolent, sorry y'all, having a moment here, desire for the victim to contract the virus, or that he was utterly indifferent to the victim's fate. The New York Court of Appeals, however, affirmed the decision of the lower court to reduce the charge of reckless endangerment in the second degree in these circumstances. And then they have a note at the bottom of the previous page that says, the risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. A person who creates such a risk but is unaware thereof solely by reason of voluntary intoxication also acts recklessly with respect thereto. And that's New York Penal Law 15.05, which seems to be totally irrelevant to what she's talking about. But we're going to move on. So it says the conduct alleged in the indictment as a violation of section 120.20 thus clearly constitutes reckless endangerment in the second degree and falls squarely within the New York Court of Appeals holding in Williams. The defendant's argument to the contrary are meritless, and the court should deny the defendant's motion. So I think if I was Judge Donnelly, I would be looking for some medical records that's proving when these people contracted herpes, when they were notified by a medical physician that they had herpes, because without proof that he knew that he had herpes, how can she then say that he gave it to her? And then how do we know she didn't give it to him, or that she didn't have it all along? So to me, I think that this needs to be tossed out unless there's some concrete proof of what is supposed to have happened and who contracted it and when they contracted it. B, count 1 is not barred by the statute of limitations. The defendant's motion to dismiss based on the statute of limitations is frivolous and demonstrates a fundamental misunderstanding of RICO. See defense motion at 11. The statute of limitations for a substantive RICO offense, the offense charged in count 1 is 5 years from the date of the indictment. See 18 United States Code at section 3282. No person shall be prosecuted, tried, or punished for any offense not capital unless the indictment is found within 5 years next after such offense shall have been committed. That certain racketeering acts are predicated on violations of state law does not mean that state statutes of limitations apply, as the defendant bizarrely asserts. See how disrespectful they are? So defense motion at 11, nor is the applicable federal 5-year statute of limitations measured from the date of the first racketeering act. This is so because the defendant is not charged with committing a particular predicate act, but rather with committing racketeering through a pattern of racketeering acts. So what they are saying here is that the state statutes don't apply because they aren't charging him with whatever the state statute is. That they're charging him with a federal crime, which is the racketeering. So then the statute of limitations change because they're incorporating these laws that were allegedly broken at the state level into the racketeering case. So before we continue, they have a note here, very long. They have 2 very long notes at the bottom. So note number 4 says, nor can it be argued that exposure to herpes from sexual intercourse does not create a substantial risk of serious physical injury to another person, as the government will establish through expert testimony at trial. Exposure to genital herpes clearly presents a substantial risk of protracted impairment of health. No, it does not. New York Penal Code 10.10, once contracted, herpes is incurable. According to the Centers of Disease Control, the first outbreak of herpes is often associated with a longer duration of herpetic lesions, increased viral shedding, making herpes simplex virus HSV transmission more likely, and systemic symptoms including fever, body aches, swollen lymph nodes, or headache. Recurrent outbreaks of genital herpes are common, and many patients who recognize recurrences have prodromal symptoms, either localized genital pain or tingling or shooting pains in the legs, hips, and buttocks. Child, what? Lord Jesus, okay. Which occur hours to days before the eruption of herpetic lesions. See Genital Herpes CDC fact sheet available at the CDC, and then they give the website. Herpetic lesions typically appear as one or more vessels or small blisters on or around the genitals, rectum, or mouth. The average incubation period for an initial herpes infection is 4 days. The range is 2 to 12 days after exposure. The vessels break and leave painful ulcers that may take 2 to 4 weeks to heal after the initial herpes infection. Now, is this the rule or the exception? Because the way they be talking about how common herpes is and the number of people that have them, you very rarely hear of these extreme conditions. So they definitely need some medical experts to come in and break all of this down. And then the note for number 5 was the statute of limitations generally is calculated using the date when an indictment is found under Federal Rules of Criminal Procedure 6E. And for statute of limitations purposes, an indictment is found when the grand jury returns it. So they're saying that their 5 years begins once the grand jury returns the indictment. Okay, so then it picks back up in their argument. And let me go back up here for the first part of the sentence. So it says, under the law, in a substantive RICO charge under Section 1962C, the defendant must have committed at least one predicate act within 5 years of the date of the indictment. United States versus Persico, which was heard by the Second Circuit in 1987. And they had the opinion that to establish a defendant's violation of Section 1962C, the government must prove that the defendant committed 2 or more predicate offenses, at least one of which occurred within the federal 5-year statute of limitations for non-capital offenses, citation omitted. Because this indictment was filed on June 20th, 2019, at least one of the predicate racketeering acts charged against the defendant in the substantive RICO count must have occurred or continued past June 20th of 2014. In this case, racketeering acts 8 through 14 all occurred after that date, and there is thus no statute of limitations issue in this case. Okay, so I think before I said it was 5 years from the grand jury meeting, but they're saying 5 years prior to the grand jury meeting. So they're saying that the grand jury met in June 20th of 2019, I guess is when the indictment was filed. So they had all the way back to June 20th, 2014 in order to have crimes occurred that they included in the indictment. So basically they went back and just dug up some stuff and made up some stuff to throw in to this indictment to fit that rule as to why they were going to charge him. So racketeering acts 2, 7, and 10 should not be dismissed. The defendant argues that racketeering acts 2, 7, and 10 of count 1, all of which relate to the production of CP, should be dismissed because there is no evidence that visual depictions exist. Defense motion at 12. This is not a proper basis for a motion to dismiss, and the motion should be denied. An indictment returned by a legally constituted and unbiased grand jury is valid on its face is enough to call for trial of the charges on the merits. Costello versus United States, and that was a case from 1956. Also, United States versus Blitz, which was a Second Circuit decision from 1976. Unless the government has made what can fairly be described as a full proffer of the evidence it intends to present at trial, the sufficiency of the evidence is not appropriately addressed on a pretrial motion to dismiss an indictment. United States versus Alfonso, which was another Second Circuit case that was heard in 1998. A defendant must wait until after the close of the government's case in chief at trial or after the jury's verdict before contesting the sufficiency of the evidence. So basically, y'all want to leave these charges as is, be able to bring this up in trial without any evidence to support it, and then after you brought it up, presented it in front of the jury, infected the jury mind with this notion that this act happened, you can then come back as you close out your portion of the trial and say, oh, no, we don't have no evidence for that. So you can go ahead and file a motion saying that that testimony shouldn't have been allowed because we can't prove it. That's basically what they're saying here. So it goes on to say, so that they were talking about a case in the Southern District of New York, 1997. But they go on to say, it is well established that an indictment that is valid on its face may not be dismissed on the grounds that it is based on inadequate or insufficient evidence. A defendant's factual arguments challenging facially valid pleadings do not justify pretrial dismissal of the indictment. The government is entitled to marshal and present its evidence at trial, and if warranted, have its sufficiency tested by a motion for a judgment or acquittal pursuant to Rule 29 of the Federal Rules of Criminal Procedure. See an example at United States versus Ariel, 1997, which was in the Southern District of New York. As the government aptly states in its opposition, while defendants' arguments may properly be considered on a motion under Rule 29 of the Federal Rules of Criminal Procedure, after the government presents its proof, they do not support dismissal of the indictment at this stage of the proceedings. A motion to dismiss a properly pleaded indictment confuses standards of pleading with standards of proof. United States versus Perez, Second Circuit, 2009. The defendants, however, had no basis to challenge the sufficiency of the indictment before trial because it met the basic pleading requirements and was valid on its face. United States versus Gotti, Southern District of New York, January 6, 2004. And in that ruling, it states the defendants will have other opportunities to contest the sufficiency of the government's evidence, but a pretrial motion to dismiss part of the indictment is not the time nor the proper occasion. United States Cassis, another Southern District of New York case from 2003. And then let's go back up here because they had another note at the bottom of the previous page. And so in this note, they say here, the initial indictment was returned on June 20th, 2019, and therefore the statute of limitations stopped running on that date. United States versus Rebuttal, from another decision from the Second Circuit, 1987. Superseding indictment made only minor technical changes to indictment, and therefore statute told by original indictment, even though superseding indictment added a murder predicate act against the defendant, even assuming arguendo that the statute of limitations was only told at the time the grand jury issued the third superseding indictment, which is not the case. There will still be no statute of limitations issue here. The grand jury issued the third superseding indictment on March 12, 2020. Document 43, racketeering acts 8 through 14 all occurred after March 12th, 2015. Ooh, that damn Ariel Clary, child, I tell you. Okay, so let's go back, pick up where we were left off. The government has not presented a full proffer of its evidence. Trial is scheduled to commence on August 18, 2021. Accordingly, the defendant's motion to dismiss these racketeering acts should be denied. And so they're basically saying that they need to be able to put on their case whether they have evidence or not, and then the defense can deal with it after the fact. So D, venue in the Eastern District of New York is proper. As the defendant concedes, his argument that venue in the Eastern District of New York is premised on the courts granting his motion to dismiss counts 6 through 9 and racketeering acts 12 and 14 of count 1. See defense motion at 12 through 13. Because the motion is baseless and should be denied, venue remains proper in this district. And I believe this is where they were asking, like, why are you filing all these charges in the Eastern District of New York that didn't actually happen in the Eastern District of New York? Moreover, the defendant is simply wrong when he asserts that counts 6 through 9 and racketeering acts 12 and 14 of count 1 are the only alleged acts in the third superseding indictment that occurred within the Eastern District of New York. ID at 12, racketeering act 9 related to Jane Doe number 5, who we know as Ariel Clary, which the defendant does not challenge in his motion to dismiss, is also alleged to have occurred within the Eastern District of New York, the Northern District of California, and elsewhere. And then, in addition, and this is a note at the bottom of the page, in addition, the defendant appears to be under the mistaken impression that witness testimony regarding certain facts, including the creation of visual depictions, is not evidence. He is wrong. Okay. So basically they're saying that they got some evidence they done made up, that they done created. That's their evidence, and that's what they're sticking to. So then the conclusion: for the foregoing reasons, the court should deny the defendant's motion to dismiss in its entirety. And that's from your homegirls over there at the Eastern District of New York. And so as I previously stated, the judge entered a ruling after this was filed, basically telling the defense if they want to respond to what the prosecutors have said, that they can respond, but that response has to be in by August 16th. And then at that point, she will make her final ruling. Don't know if that's a good or a bad thing, like if she's made up her mind already, or the fact that she's giving them so much time to, whether they're going to get like 3-4 extra days. The trial starts 14, 15, 16. The trial starts Wednesday. So she's giving them until Monday. Okay, so they have the weekend to work on this. They don't have a lot of time. They need to work on this over the weekend and file their motion on Monday, and then she will make her ruling. So guys, that's it for me. Don't forget, go to the community page to check out the list of Jane Does. Let's just turn it into a little game to figure out who they are. And give me your feedback, whether you think the ones I got right are right. If you think that they are wrong, tell me why they're wrong and who it should be. And then if you have any guesses on who the unnamed people are, the ones that I couldn't find any relative information on through my search, then go ahead and drop that in the comments as well and tell me who you think those people are. So that's it for me. Go ahead, leave your comments below, rate the video, subscribe to the channel. Have a wonderful, wonderful weekend. And until the next time, I shall talk to you guys later. Bye-bye.